So the DOJ says that Illinois gun and magazine ban violates the Second Amendment. Now that's the United States Department of Justice.
Interesting.
And we've talked about how this is pretty big. Like, this is not symbolic. This is a very big thing, and I wanted to bring it to everybody's attention. So we've talked about how Trump's DOJ is doing a fantastic job of defending the Second Amendment. They've turned it into what it turned in their arguments and their position into exactly what the Second Amendment is, which is a civil right. They're treating it like the civil right that it is. And so what happened, there are a lot of different gun bans, magazine bans, or what they like to call assault weapon bans across the country. And Illinois is one of the very few states, like California, Massachusetts, New Jersey, that has a gun ban that they call an assault weapons ban. So the U.S. DOJ came out with a statement that says, hey, this is unconstitutional. That's our stance. This is unconstitutional. And Bearing Arms did a really great article on it. Cam Edwards, fantastic guy. The Trump administration has taken another historic step in defense of the right to keep and bear arms by declaring in an amicus brief that Illinois' bans on commonly owned semi-automatic firearms and ammunition magazines that can hold more than 10 rounds violate the protections of the Second Amendment. This is huge. They issued this brief. The DOJ argued that there are, quote, 3 very good reasons why an appellate court should reverse course and affirm the district court's permanent injunction despite overturning U.S. District Judge Stephen McGlynn's earlier decision granting a preliminary injunction against the gun and magazine ban. Now, this is right from the brief. The position fails as a matter of text, history, and precedent. The Second Amendment prefatory clause, a well-regulated militia being necessary to the security of a free state, certainly does not limit the scope of its operative clause, as the Supreme Court made clear in Heller, but the Supreme Court was just as clear that the prefatory clause's text nevertheless announces one of the Second Amendment's purposes, and logic demands that there be a link between the stated purpose and the command. The Second Amendment's militia-related text, as interpreted by the Supreme Court, thus suggests that the government may not prohibit weapons simply because it considers them militaristic. The contrary claim that militaristic weapons fall outside of the scope wrongly requires reading the prefatory clause entirely out of the Second Amendment. Now, in a couple of episodes, we've actually talked about that. How people are saying, hey, you know what? An AR that a civilian purchases isn't a weapon of war. This decision, this brief is basically saying, hey, it absolutely has a military or militia purpose, and therefore that's one of the big reasons it can't be banned. Then it goes on to say, even the Miller case, which we brought up in previous episodes, even the Miller case from the 1930s held that only those arms best suited for a militia are protected under the Second Amendment, which the Seventh Circuit and other appellate courts appear to have simply ignored in order to uphold an AR-15 ban. And then again from the brief, multiple Supreme Court justices, including Bruin's author, have since made it clear that they disagree with Bevis and other recent lower court opinions, and that the court is likely to grant a certiorari in the next term or two, which is what Kavanaugh said. The next term or two, they're going to have some kind of decision on an assault weapons ban, quote-unquote assault weapons ban, to address the errors in this opinion. Third, after the court's decision in Bevis, the district court held a multi-day bench trial, heard significant evidence regarding the issues in the case, and made factual findings that show that the act violates the Second Amendment as applied to semi-automatic firearms and attachments that are in common use by law-abiding citizens for lawful reasons. So this is huge. This is yet another instance where the Trump administration is by far the strongest Second Amendment presidential administration that has ever existed, at very least in modern times. I mean, it is phenomenal what's going on. The fact that the Trump administration's Department of Justice submitted an amicus brief saying, hey, you can't ban semi-automatic rifles that you choose to refer to as assault weapons. You can't ban their accessories. You can't ban crucial parts like magazines, no matter how many rounds that they show. Enormously important and extremely, extremely helpful. So I wanted to point that out. Okay, that is your legal and legislative segment. I wanted to point all that out and bring you up to speed. Now you know all you got to know. Hey, thanks for watching Gun Owners Radio. I hope you loved that clip. Don't forget to like, subscribe, comment, and follow us on social media. And check out our website at gunownersradio.com.